Rules on Civil Procedure, Rule 24. Depositions before action or pending appeal. Section 1. Depositions before action, petition. A person who desires to perpetuate his or her own testimony or that of another person regarding any matter that may be cognizable in any court of the Philippines may file a verified petition in the court of the place of the residence of any expected adverse party. Section 2. Contents of petition. The petition shall be entitled in the name of the petitioner and shall show a. That the petitioner expects to be a party to an action in a court of the Philippines but is presently unable to bring it or cause it to be brought. B. The subject matter of the expected action and his or her interest therein. C. The facts which he or she desires to establish by the proposed testimony and his or her reasons for desiring to perpetuate. D. The names or a description of the persons he or she expect will be adverse parties and their addresses so far as known. And E. The names and addresses of the persons to be examined and the substance of the testimony which he or she expect to elicit from each and shall ask for an order authorizing the petitioner to take the depositions of the persons to be examined named in the petition for the purpose of the perpetuating their testimony. Section 3. Notice and Service. The petitioner shall serve a notice upon each person named in the petition as an expected adverse party, together with a copy of the petition stating that the petitioner will apply the court at a time and place named therein for the order described in the petition. At least 20 calendar days before the date of the hearing, the court shall cause notice thereof to be served on the parties and prospective deponents in the matter provided for service of summons. Section 4. Order and examination. If the court is satisfied that the perpetuation of the testimony may prevent a failure or delay of justice, it shall make an order designating or describing the persons whose deposition may be taken and specifying the subject matter of the examination and whether the deposition shall be taken upon oral examination or written interrogatories. The depositions may then be taken in accordance with Rule 23 before the hearing. Section 5. Reference to court. For the purpose of applying Rule 23 to depositions for perpetuating testimony, each reference therein to the court in which the action is pending shall be deemed to refer to the court in which the petition for such deposition was filed. Section 6. Use of deposition. If a deposition to perpetuate testimony is taken under this rule, or if, although not so taken, it would be admissible in evidence, it may be used in any action involving the same subject matter, subsequently brought in accordance with the provisions of Section 4 and 5 of Rule 23. Section 7. Depositions pending appeal. If an appeal has been taken from a judgment of a court, including the Court of Appeals in proper cases, or before the taking of an appeal, if the time therefore has not expired, the court in which the judgment was rendered may allow the taking of depositions of witnesses to perpetuate their testimony for use in the event of further proceedings in the said court. In such case, the party who desires to perpetuate the testimony may make a motion in the said court for leave to take the depositions upon the same notice and service thereof as if the action was pending therein. The motion shall state a. The names and addresses of the persons to be examined and the substance of the testimony which he or she expects to elicit from each, and b. The reason for perpetuating their testimony. If the court finds that the perpetuation of the testimony is proper to avoid a failure or delay of justice, It may make an order allowing the depositions to be taken, and thereupon the depositions may be taken and used in the same manner and under the same conditions as are prescribed in these rules for depositions taking in pending actions. Rule 25. Interrogatories to parties. Section 1. Interrogatories to parties, service thereof. Upon ex parte motion, any party desiring to elicit material and relevant facts from any adverse parties shall file and serve upon the latter written interrogatories to be answered by the party served, or if the party served is a public or private corporation or a partnership or association, by any officer thereof competent to testify in its behalf. Section 2. Answer to interrogatories. The interrogatories shall be answered fully in writing and shall be signed and sworn to by the person making them. The party upon whom the interrogatories have been served shall file and serve a copy of the answers on the party submitting the interrogatories within 15 calendar days after service thereof, unless the court, on motion and for good cause shown, extend or shorten the same. Section 3. Objections to interrogatories. Objection to any interrogatories may be presented to the court within 10 calendar days after service thereof, with notice as in case of a motion, and answers shall be deferred until the objections are resolved, which shall be at as early as time as practicable. Section 4. Number of interrogatories. No party may, without leave of court, serve more than one set of interrogatories to be answered by the same party. Section 5. Scope and use of interrogatories. Interrogatories may relate to any matters that can be inquired into under Section 2 of Rule 23, and the answers may be used for the same purposes provided in Section 4 of the same rule. Section 6. Effect of failure to serve written interrogatories. Unless thereafter allowed by the court for good cause shown and to prevent a failure of justice, a party not served with written interrogatories may not be compelled by the adverse party to give testimony in open court or to give a deposition pending appeal. Admission Rule 26. Admission by adverse party. Section 1. Request for admission. At any time after issues have been joined, a party may file and serve upon any other party a written request for the admission by the latter of the genuineness of any material and relevant document described and exhibited in the request or of the truth of any material and relevant matters of fact set forth in the request. Copies of the documents shall be delivered with the request unless copies have already been furnished. Section 2. Implied admission. Each of the matters of which an admission is requested shall be deemed admitted unless, within a period designated in the request, which shall not be less than 15 calendar days after service thereof, or within such further time as the court may allow on motion, the party to whom the request is directed files and serve upon the party requesting the admission a sworn statement either denying specifically the matters of which an admission is requested or setting forth in detail the reason why he or she cannot truthfully either admit or deny those matters. Objections to any request for admission shall be submitted to the court by the party requested within the period for and prior to the filing of his or her sworn statement as contemplated in the preceding paragraph, and his or her compliance therewith shall defer until such objection are resolved, which resolution shall be made as early as practicable. Section 3. Effect of admission. Any admission made by a party pursuant to such request is for the purpose of the pending action only and shall not constitute an admission by him or her for any other purpose, nor may the same be used against him or her in any other proceeding. Section 4. Withdrawal. The court may allow the party making an admission under this rule, whether expressed or implied, to withdraw or amend it upon such terms as may be just. Section 5. Effect of failure to file and serve request for admission. Unless otherwise allowed by the court for good cause shown and to prevent a failure of justice, a party who fails to file or serve a request for admission on the adverse party of material and relevant facts at issue which are or ought to be within the personal knowledge of the latter shall not be permitted to present evidence on such facts. Section Rule 27. Production or inspection of documents or things. Section 1. Motion for production or inspection order. Upon motion of any party showing good cause therefore, the court in which an action is pending may a. Order any party to produce and permit the inspection and copying or photographing by or on behalf of the moving party of any designated documents, papers, books, accounts, letters, photographs, objects or tangible things not privileged which constitute or contain evidence material to any matter involved in the action in which are in his or her possession, custody or control, or B. Order any party to permit entry upon designated land or other property in his or her possession or control for the purpose of inspecting, measuring, surveying, or photographing the property or any designated relevant object or operation thereon. The order shall specify the time, place, and manner of making the inspection and taking copies and photographs, and may prescribe such terms and conditions as are just. Rule 28. Physical and mental examination of persons. Section 1. When examination may be ordered. In an action in which the mental or physical condition of a party is in controversy, the court in which the action is pending may, in its discretion, order him or her to submit a physical or mental examination by a physician. Section 2. Order for examination. The order for the examination may be made only on motion for good cause shown and upon notice to the party to be examined and to all other parties, and shall specify the time, place, manner, conditions, and scope of the examination and the person or persons by whom it is to be made. Section 3. Report of findings. If requested by the party examined, the party causing the examination to be made shall be delivered to him or her a copy of the detailed written report of the examining physician, setting out his or her findings and conclusions. After such request and delivery, the party causing the examinations to be made shall be entitled upon request to receive the party examined a like report of the examination, previously or thereafter made, of the same mental or physical condition. If the party examined refuses to deliver such report, the court on motion and notice may make an order requiring delivery on such terms as are just. And if a physician fails or refuses to make such a report, the court may exclude his or her testimony if offered at the trial. Section 4. Waiver of privilege. By requesting and obtaining a report of the examination so ordered or by taking the deposition of the examiner, the party examined waives any privilege or he or she may have in that action or any other involving the same controversy regarding the testimony of every other person who has examined or may thereafter examine him or her in respect of the same mental or physical examination. Rule 29. Refusal to comply with modes of discovery. Okay. Section 1. Refusal to answer. If a party or other deponent refuses to answer any question upon oral examination, the examination may be completed on other matters or adjourned as the proponent of the question may prefer. The proponent may thereafter apply to the proper court of the place where the deposition is being taken for an order to compel an answer. The same procedure may be availed of when a party of a witness refuses to answer any interrogatory submitted under Rule 23 or 25. If the application is granted, the court shall require the refusing party or the opponent to answer the question or interrogatory, and if it also finds that the refusal to answer was without substantial justification, it may require the refusing party or the opponent or any counsel advising the refusal, or both of them, to pay the proponent the amount of the reasonable expenses incurred in obtaining the order, including attorney's fees. If the application is denied and the court finds that it was filed without substantial justification, the court may require the proponent or the counsel advising the filing of the application, or both of them, to pay to the refusing party or the opponent the amount of the reasonable expenses incurred in opposing the application, including attorney's fees. Section 2. Contempt of court. If a party or other witnesses or if a party or other witness refuses to be sworn or refuses to answer any question after being directed to do so by the court of the place in which the deposition is being taken, the refusal may be considered a contempt of that court. Section 3. Other consequences. If any party or an officer or managing agent of a party refuses to obey an order made under Section 1 of this rule, requiring him or her to answer designated question, or an order under Rule 27 to produce any document or other thing for inspection, copying, or photographing, or to permit it to be done, or to permit entry upon land or other property, or an order made under Rule 28 requiring him or her to submit a physical or mental examination, the court may make such orders in regard to the refusal as are just, and among others, the following. A. An order that the matters regarding which the question were asked and the character or description of the thing or land, or the contents of the paper, or the physical or mental conditions of a party, or any other designated facts shall be taken to be established for the purposes of the action in accordance with the claim of the party obtaining the order. B. An order refusing to allow the disobedient party to support or oppose designated claims or defenses, or prohibiting him or her from introducing in evidence designated documents or things or items of testimony, or from introducing evidence of physical or mental condition. An order striking out pleadings or parts thereof, or staying further proceedings until the order is obeyed, or dismissing the action or proceeding or any part thereof, or rendering a judgment by default against the disobedient party. And D. In lieu of any of the foregoing orders, or in addition thereto, an order directing the arrest of any party or agent of a party for disobeying any such orders, except an order to submit to a physical or mental examination. Section 4. Expenses or refusal to admit. If a party, after being served with a request under Rule 26, refuses to admit the genuineness of any document or the truth of any matter of fact, serve a sworn denial thereof, and if the party requesting the admission thereafter proves the genuineness of such document or the truth of any such matter of fact, he or she may apply to the court for an order requiring the other party to pay him or her the reasonable expenses incurred in making such proof, including attorney's fees, unless the court finds that there were good reasons for the denial, or that admissions sought were of no substantial importance. Such order shall be issued. Section 5. Failure of party to attend or serve answers. If a party or an officer or managing agent of a party willfully fails to appear before the officer who is to take his or her deposition after being served with a proper notice, or fails to serve answers to interrogatories submitted under Rule 25 after proper service of such interrogatories, the court on motion and notice may strike out all or any part of any pleading of that party, or dismiss the action or proceeding, or any part thereof, or enter a judgment by default against that party, and in its discretion order him or her to pay reasonable expenses incurred by the other, including attorney's fees. Section 6. Expenses against the Republic of the Philippines. Expenses and attorney's fees are not to be imposed upon the Republic of the Philippines under this rule.